your attention, Ron has graciously come today, and we appreciate it. I say he's our walking encyclopedia. He's our, the perfect person to ask different questions with, and he's so loyal to Naifa. He's a Naifa friend, and we appreciate it. And you should be here till 4:30, and his office probably tomorrow, the next couple of days, will put your CE in. So if you have any questions, just give me a call. But Ron, thank you.
Great.
Ron Martin.
Thank you, Ron.
Thank you. I appreciate it. I'm trying some new technology today, so hopefully nothing will mess up. I've got a new Surface tablet, and so it's the first time I've presented with it, and I'm also doing some recording of that as well. So hopefully we won't have too much technical problems as we go. The topic today is estate and tax law update for 2015. We've had a lot of interesting things happen in state law, specifically in the estate and tax arena, and so we'll talk about a lot of those things. We'll talk about some about the Uniform Trust Code that Mississippi passed last year. We'll talk a lot about the Qualified Disposition and Trust Act that was passed last year, because your clients will likely have some questions about that along the way. We'll talk about other asset protection planning techniques that apply, and we'll talk about trust law in general along the way. The other thing we'll talk about this morning, or this afternoon I should say, is the protection of IRA assets for inherited IRAs, methods of protecting that. We had a landmark decision by the U.S. Supreme Court about 6 months ago, and so we'll talk about the impact of that decision and what you can do to circumvent the bad results of that decision, some places that trust may come into play in your IRA planning for your clients. And then finally, we'll talk a lot about Medicaid planning techniques that are appropriate for your clients, and kind of give you some general knowledge, some general information, so that when those issues come up, because those are questions that are coming up more and more frequently for all of us as advisors, and so this will hopefully arm you with some information on that. Feel free to ask questions along the way, but we'll get started. Asset protection using revocable and irrevocable trusts, as well as other tools, is a common area of question and concern that we get coming through our office, and no doubt you likely get those questions as well. And so this hopefully will arm you with some basic information. I'm going to go pretty basic on you, and hopefully not too basic. We'll make an assumption that none of you know anything about trust, and then we'll kind of move you up from there. So if you already know a lot about trust, this first part will be a little bit boring for you, but hopefully you'll see some areas where you can use trusts in a manner that will benefit your clients that they may not realize and that you may not be familiar with. There are really 5 main ways of transferring property or when one dies. One way is automatically through form of title. So that would be like joint tenancy with right to survivorship, or tenancy in common. The two owners own the property jointly, and in that case the survivor then owns it in its entirety upon the death of the first. It's a very common way for husbands and wives to own property. It's very easy to transfer property in that manner. It's usually a deed or just a change to a bank account or something along those lines. It avoids probate. It's a very good, easy way of just shifting assets over. As far as tenancy and joint tenancy with rights to survivorship, there's no creditor protection in that. Even though the title shifts on its own, it is subject to the creditor claims of the first co-owner. Tenancy by the entirety will protect against creditor claims of the first decedent. And so sometimes we advise clients to put assets in ownership of tenancy by the entirety, so that if there was a creditor claim at death, that death wipes out that claim with respect to that particular asset, so the survivor spouse owns that. The catch is that for tenancy by the entirety, it's limited to husbands and wives. So anybody can own, no relationship at all, can own joint tenants with rights to survivorship, but tenancy by the entirety is limited to the spousal relationship. Another way of owning of transferring assets, which all of you members of Naifa are well aware of, is by contract designation. And so it's typical example of that is a life insurance policy, or a annuity, or an IRA or 401k, anything that has a beneficiary designation on it. The contract is what controls the terms of that fiduciary holding those assets, and the contract will provide, upon death of this individual, this is where it goes. And all those contracts that we're familiar with, it goes where you say it goes, whoever you designate as your beneficiary, and then if not, the default is going to be the estate of the individual, typically there. So it will pass automatically. Again, a very good way of transferring assets, avoids probate, avoids all the rigmarole of that, passes directly to the beneficiary. So a very good way of holding an asset that can quickly and efficiently transfer upon the death of an individual. Transfer on death statutes, that's what we all see on these bank accounts, TOD or POD, pay on death or transfer on death. It's a creature of statute. There's no common law right to name someone as a beneficiary of an asset. But by statute, there are certain types of assets that can be treated that way. So it basically gives you a beneficiary designation over an asset that is not by contract. But if there's an asset that's not covered by the statute, then you can't do a transfer on death, or at least a valid transfer on death ownership. And so bank accounts are the typical example. And so we open a bank account, it's my bank account, but transfer this account on my death to my spouse or my child. And now we've avoided probate with it. We've had an easy way of transferring title to it, but it only works because we got a statute that says it works. Now, interestingly, who can be a beneficiary of that? Certainly a natural person can be a beneficiary. The question comes up, can a trust be a TOD beneficiary of an asset? And revocable trusts can, because the statute specifically includes revocable trusts as a valid TOD or POD beneficiary. Many banks around in the Mississippi area read that to mean, well, that must mean it excludes irrevocable trust, because the statute is silent with respect to irrevocable trust. And so many banks that we deal with around here say, well, you can't name that trust as a beneficiary because it's an irrevocable trust. So we run into that sometimes. Frequently when that happens, what we will do is we'll create, if the main trust that we're dealing with is an irrevocable trust, we will create a standalone revocable trust that does one thing. It pours any assets that it has over into the irrevocable trust. And so now we can legally name this trust that then just pours over. So it's just an extra piece of, stack of paper basically that we can provide the bank to meet their interpretation of the statute. I'm not convinced that they're right on that interpretation, but we're stuck with what their legal department says, and so we just abide by it. But that's kind of the way around that to be able to get those assets to the irrevocable trust ultimately. Probate is kind of the default way of transferring title to property. And we're all familiar with probate either personally or through clients. Probate is the act of transferring assets legally, transferring legal title of assets from a deceased person to a living person. That's all probate is. And so basically, if we need the signature of someone to transfer title, and that signature has to come from the grave, because that person is deceased, then probate is the way that we get the signature from the grave to transfer it. That's what probate's for. We do it for two reasons. One, we want to protect creditors. If somebody dies owing you money, you ought to have an orderly process to be able to collect that money before it gets distributed out to their kids. Because if it gets distributed out to their kids, you're never going to see your money. It's going to fly all sorts of places, and so that's the mechanism we have to have an orderly way of determining, number one, is your debt valid, and number two, how you get paid and the order you get paid. And so that's one reason that probate exists. The second reason it exists is so we can have a good record of title. So when you and I go buy a car, when you and I go buy a piece of property, we know that we're buying it from the legal owners. We're not taking their word for it. Well, yeah, Dad died and we're the sole heirs, and so we're selling it to you. Well, you take their word for it at your own risk, because some stepchild comes up that's also an heir and comes knocking on the door at midnight saying, hey, this house is a third mine. My dad owned this house when he died. And so nobody wants that midnight knock at the door. No bank wants that. And so you're not going to get financing on an asset unless it's gone through that probate process or some other mechanism to make sure and clear out any of those unknown creditors, any of those potential unknown heirs out there. And the probate process does that. It wipes those heirs out. It makes clear this is the determinative heirs that we've got. And so we have two types of probate. We have testate probate or intestate probate. Testate means the person died with a will. And so a very common way transferring assets at death, someone does a will, the will operates through the probate process. So at death, we file the will with the court looks at it and says, yeah, it looks like a valid will to me, enters an order appointing the person named in the will typically as the executor of the estate, and that person now is in charge, answering to the court, but doing the things that are required to be done, notifying creditors, notifying heirs, paying creditor claims out, and such as that, and then ultimately reporting back to the court of a determination of heirs, termination of creditors, and distributing those assets out. If you die without a will, Same process is followed, except the person, instead of being an executor, it's called an administrator, or we call that an intestate estate. Instead of the will saying who gets what, the statute says it. And the statute's going to say, we're going to divide equally between descendants and a spouse, if there is one. And we're going to do that per stirpes, out about 5 generations, basically. And so there's no modifying that the way you could in a will, but the statute itself is going to declare what, where those assets go. And so that's what the court oversees in the probate process. If you have an intestate estate, there's usually one other step that we generally will go through, and that is a determination of heirs. We don't care about the determination of heirs so much in a testate estate, because we got a will that says, these are my children. We got a will that says, this is who gets what. And so even if we left a child out, we got a will that says who gets what. We're not that concerned if there's unknown heirs or undetermined heirs or illegitimate heirs out there. In an intestate estate, though, we got a statute that says children get a share. And so we've got to determine how many children are there. And so the legal way of doing that is we file notice to the world, have a hearing on determining those heirs, and then the court then is satisfied that, okay, these are the only children of the decedent. And so that's kind of how that process works. General process, by the way, if you've not been through it, on a fairly basic estate, which most estates that we deal with in Mississippi are, 6 months to 9 months is a fairly typical time frame. If you have a complicated estate, complicated may mean a lot of moving parts, like businesses and things, or complicated may mean a lot of heirs, a lot of disputes among heirs and things. That will cause that process to be longer. And so you may be looking at years in an estate like that. I've been involved in estates that have taken over a decade to settle, but that's unusual. Again, the norm is generally 6 to 9 months, in that process. The final way of transferring assets is through a trust. And a very common way of doing that is through something called a living trust, or a revocable living trust. And a revocable living trust is a method basically of a will substitute to transfer assets from an estate down to the next generation without court involvement. And we'll talk a little bit about, in greater detail, about kind of how that process operates.